So hi, everybody. Thank you very much for joining us today. I'm sure that more people will join in us, but we can start. My name is Amaya Delgado. I'm the Secretary General of the Spanish Business Council, and I want to welcome you to this webinar about the labor law of the United Arab Emirates. We have here today with us two amazing experts, Alejandro Esmoriz, Senior Associate at Bonar Lawson, and Ahmed Bach, Legal Advisor General Law and Elnagar & Partners. Both legal firms, Bonar Lawson and Elnagar & Partners, are members of the Spanish Business Council. And I'm really thankful because they decided to join us. The Spanish Business Council being two international law firms. This is one of the amazing things here in the UAE, in Dubai, that it's an international community, and although most of the members of the SBC are Spanish, not all of them are. And together we are creating an amazing city, an amazing environment to work and to have business here in the UAE. So I just don't want to steal more time to our experts because they are the ones that are providing this amazing knowledge. So we start with Alejandra. Alejandra, please go ahead. And thank you very much.
Thank you, Amaya, for this introduction, and thank you to the Spanish Business Council for hosting this webinar. Welcome to everyone to this session on the new labor law. My name is Alejandra Esmoriz. I'm a senior associate at Bonar Lawson International Law Firm in their private client practice. I regularly advise clients on employment matters. Today, it will be the occasion to review some important changes that have been introduced with the new regulation, and try to share also some experiences. I will be joined by Ahmed Gabr from the law firm Elnagar & Partners for this session. So without further ado, the agenda for the session of today will be the following. I will start with a brief overview of the new regulations and some key changes that have been introduced. We will continue by reviewing the new work models that have been introduced through the new regulation. We will continue with the question related to the duration of contract. You will see that some very important changes have been introduced in this regard. Then we will continue with the questions related to probationary periods and leaves. And finally, we will review also termination of employment contracts, and obviously the question of the end of services that I'm sure most of you might be very, very interested. If we have still a bit of time, we will have a Q&A session at the end, and we will try to answer your questions as much as we can. If we can, we will try to get back to you later on. So please do not hesitate to write your questions in the chat box, and we will try to do our best to take them at the end. Without further ado, let's start with the introduction part of this session. So what you need to understand is that very recently, a new federal law, the federal law number 33/2021, has been enacted, replacing the previous labor law. And this new regulation came into force on the 2nd of February 2022, and has been completed by the cabinet decision, which we will call the executive regulation. These executive regulations have been also released in February 2022, providing a totally new legal framework for UAE labor law. And this new legal framework applies across the UAE, including free zone jurisdictions, except for the AFC and ADGM, because those two financial free zones have their own set of labor regulations. So with the introduction of this new labor law, one of the aim of the lawmakers was to ensure that the UAE labor regulation is aligned with the best international practice in this matter. And among the objectives that have been written in the law, we have the fact that the new law should provide more flexibility and sustainability for the UAE labor market. It needs also to provide more protection, work-life balance also for employees, and provide some support and rehabilitation while attracting talented and skilled employees here in the UAE market. So what are the key changes that have been introduced? Among them, what we can say is that, for example, for the first time, we have the principle of equality and non-discrimination that has been, for example, written down in this new regulation, and especially for female workers. It's specifying that female and male workers should receive the same type of wages at equal work. Another key change is the fact that it's clearly mentioned that forced labor, sexual harassment, or bullying is forbidden, providing more security for employees here in the region. Another key change is the fact that new working models have been introduced with a new set also of work permits. We have seen also that this new regulation has introduced a new leave regime, and Ahmed will provide you a more detailed information in this regard. And we have seen also that the maternity leave has been enhanced through this new regulation, which is very welcome for any female worker who are currently working in the UAE, and to make sure that they might eventually have a bit more security in this regard. One of the changes that have been implemented, and that maybe might be a bit more surprising, is the fact that under the new new regulation, unlimited employment contracts are not anymore allowed, meaning that if there is any unlimited employment contract that was entered into by an employer and employee under the old regulation, this contract will need to be changed to a limited contract. While this might be a bit surprising, especially for employees who have been under an unlimited employment contract for a very long time. The fact that there is a transition to this new kind of model of duration of contract doesn't imply that the rights in terms of gratuities might not be calculated from the first contract, okay? But it's important to understand that employers will have 1 year to amend the duration of employment contracts in case they have this kind of unlimited agreements in place. We'll now continue with the new work models. So under the old regulation, there was usually only one working model, which was the full-time employee. With the new regulation, we have the introduction, in fact, of 4 new work patterns. The first one is obviously the full-time work pattern, which is the standard and the one that we are used to. Then we have the part-time. We have also the temporary and the flexible. Regarding the part-time option, This means that an employee can work for one or more employers for a specified number of working hours, or, for example, for a specific number of working days during the week. Regarding the temporary part-term, we have the option, in fact, for an employee to work for a specified duration of time or for specific task. And this type of contract will end with the completion of the duration or the task. The last work pattern is the flexibility one, which involves a variable working hours or days per week. And this kind of model has the advantage to be very flexible, to adapt according to the workflow or the economic or operational needs of a company. On top of that, in fact, the executive regulation have added 2 additional work patterns, which are the remote work and the job sharing. By remote work, we are referring to the fact that the work is completely or partially performed outside the workplace, and that in fact the employee is not working in person at, for example, the facilities of the employer, but he will work outside, and eventually he will communicate with the employer through electronically means mainly. The work in that case might be part-time or full-time. This will depend on the situation. But what is important is just to make sure that, in fact, the worker is not obliged anymore to perform the work inside the office of the employer, but can work remotely. Another working model is the job sharing, meaning that tasks and duties might be divided between more than one worker. And those workers, when working as together based on a job sharing model, will be subject to, in fact, the provisions of the part-time work in the regulation. In parallel, the regulations, the executive regulations, have introduced new work permit categories. Under the old regulation, all expatriate employees needed to obtain an employment permit before they could be legally employed in the UAE, and normally there was only one form. And in that case, normally the employee was hired on a full-time employment permit. With the new law, we have the introduction of 12 categories of work permits. And among the most interesting new types, we can mention, for example, the temporary work permit, the one-mission work permit, the part-time work permit, the juvenile permit, or the freelance permit. So these work permits will allow, in fact, to employers to implement, in fact, the new work models that have been presented before, and facilitate, in fact, to understand what are the obligations and rights of all the parties implicated in this relationship, because the different type of working models have been implemented in the regulation, and the rights and obligation of the parties have been clarified in those regulations. I just wanted to mention that, in addition to this, to the 2 regulations that have been mentioned earlier, the Ministry of Labor has also released the administrative resolution number 2020, the resolution number 22 of 2022, providing further guidance on the different categories of work permits, regarding typically the requirements, the duration of the work permits, and the fees. This resolution is accessible in the website of the ministry, so please do not hesitate to visit their website, because you might find a lot of additional information that can be very useful. Now that we have presented briefly the new work models, what does it change in practice? So here I will just take two simple scenarios to try to explain why these new work models might be really something that could be leveraged not only by employers, but also by the employees. First scenario, let's say you have an employee who is willing to work part-time because he or she has family obligations, and as an employer, you consider that this is a suitable arrangement for all of you, for the employer, for the employee, and for the company. Under the old regulation, the employer needed to hire this employee as a full-time worker. Of course, the employer and the employee could have some sort of side agreements and to allow the employee to work on a part-time basis. However, the rights and obligation of each party, especially regarding gratuities, leaves, were not necessarily clear, because this was not reflected in the regulation. And obviously, this could lead to some dispute in case of termination of the contract of the employee, and then the employee claiming leaves or gratuities based on a full-time contract. The new law allows to remedy this kind of uncertainty by introducing the part-time working model. So not only the employer can hire an employee on a part-time contract, but the law contains specific dispositions in relation with the calculation of the gratuities and the leave for those employees that are under a part-time contract. From my perspective, this obviously provides more flexibility and security for both sides, and I think that this change is really welcome. The second scenario, it's, for example, let's say you have, as an employer, you have an increase of work because you have a new project or you have a new mandate, or eventually one of your full-time employees, he's on a long sick leave, or eventually you have one of your employees who is in maternity leave. Under the old regulation, again, the employer needed either to hire a full-time employee and eventually terminate this employee to absorb, it was necessary to hire the full-time employee to absorb the additional work to be done, and eventually terminate the contract of this resource when the resource was no longer needed. Another alternative would have been also to hire someone through an agency or a manpower company for a certain period of time. But then you have always the question of the termination of the contract, and then again the calculation of the leaves, the gratuities, etc., etc. Under the new law, this kind of situation might be solved in a different situation, because it's possible for employers now to hire a new resource on a temporary basis, or, for example, a one-mission work permit. And with this flexibility, again, you might hire the resources that needs the company to cover a specific project, or to cover a specific period of time, to make sure that in fact, the company will be able to assume the additional workload for a specific time, without the necessity to hire a full-time employee that could lead not only to at some point, eventually you have less work, and then you will have the question of what do I do with this resource that has been hired full-time? Because with a temporary basis permit or a one-time work permit, you know that once the duration or the mission is completed, the contract will end automatically. Of course, if you consider that this person should be hired later on as a full-time employee, you have always this possibility. In conclusion, from my perspective, the introduction of these new working models, the introduction of these new working models and new categories of work permits allow to give more flexibility to both employers and employees to adapt to their respective needs and priorities, and also for employees to eventually take into consideration some work-life balance. I will now hand over to Ahmed, who will continue this presentation. Ahmed, the floor is yours.
Thank you very much indeed, Alejandra. Just facing a bit of problem in connection, but I will be here in just 1 second. Thank you very much, Alejandra. That was really awesome information. You're hearing me well, right?
Yes.
Yeah, that's very good. Thank you to all of our participants for joining our webinar. And I would like to continue from where Alejandro stopped, because actually we have a lot of information to digest in the upcoming 30 minutes. So we would head directly to the slides. And I would like first to start with the duration of the contract. So here we are assuming that the contract has been conducted between the employer and the employee. And according to the new duration and the new nature of the contract, we will find that we have only a maximum duration of 3 years and one nature only, which is the limited contract. There's no more unlimited contract, which is a given fact. And the contract could be limited of 1 year, 2 years, or 3 years. And by navigating the Article 8 of the law, we can see that the employer must conclude an employment contract with the worker, the employer, according to the form of work agreed upon, provided that the contract in a 2 copies, this was a given fact in the previous law as well, on which shall be kept by the employer and the other shall be handed to the worker. And this is a very important thing, that you should handle to your worker, employee, the employer, the copy of the labor law, of the labor contract, I'm sorry, in accordance with the forms specified in the executive regulations, which is my colleague Alejandra referred to in her speech. And the second clause is or is representative. Excuse me. Representative is a very general word, but it has a very deep meaning. Representative should be authorized by the worker. The worker is the employer, either the company or the authorized person who represents the company before the authorities, to avoid any problems, to avoid any glitch with the authority, to avoid any delay in the procedure itself of the contract. The one who represents the company should be authorized to represent the company. The representative might be the PRO, might be the HR, might be as appointed, but the appointment should be done according to his visa title, according to his information, which is submitted to the Ministry of Labor. So the worker or his representative may establish the employment contract, the amount of wage, and the rights entitled under the provisions of this decree. This was also a given fact in the old law, and I'm trying to define the new law and the old law. I'm not doing a compare. I'm just defining, because the differences are not too much. However, it is a very specific and very important to be highlighted. So we can continue with the clause number 3 of Article 8, that the employment contract shall be concluded for a specific period, which not exceeding 3 years. That means that you have the right to conclude this contract for the period of 1 year, 2 years, or even 3 years. And it is permissible by mutual agreement between parties to extend or renew this contract. The meaning of by mutual agreement between the parties, that this agreement could be a written agreement and could be a vocal agreement, like not a written one. However, it is not mandatory later on to let's say that the employer has promised the employee that they will have another contract, or they will extend this contract for another 3 years. If the employee insists to have a written agreement in this regard, then this written agreement is pending for both parties. And there are no much cases for that, but it all falls under the civil compensation in case if the employer breached this agreement or did not honor the agreement at the end of the contract. And in the event of an extension or renewal of the contract, the new period shall be deemed to be an extension of the original period, means that the gratuity, the full and final settlement, or the entitlements, the financial rights of the employee shall continue to the next period. So if it's 3 years, then we renew it for 2 more years. We're talking about 5 years of contract, 5 years of a labor relationship between the employer and the employee. And if both parties continue to implement the contract after the expiry of its original term or the expiry of the agreed open work without express agreement, in this case that we don't have an agreement, our contract is done, it's finished, expired. However, we're continuing the obligations. I'm continuing to come to work, and the employer continues to pay me. And in this case, for sure, the extended contract will be based on the same conditions stated therein in the previous contract. And the executive regulation of the decree is very important to be reviewed by the participants if the participants wishes to extend the understanding to the terms of this law, to the articles of this law. And the executive regulation could be easily found on Thomson Reuters or Nexus, or in English and maybe in Spanish as well. I don't know. Let's go for the next chapter, which is the probation periods. Of course, the probation period is one of the most important changes that have been brought to this law, because the probation period in the previous law was just giving the right to the employer to test the employees that he is hiring. The probation period was also 1, 3, or 6 months. And during the probation period, we can say that the labor relationship between the employer and the employee is not solid enough to base any obligation between both of them. The employee can serve a notice, and the employer can serve a termination at any time. None of them will be punished, or none of them will be, the losses will not be that high. However, in the new law, as we can see, that the employer may appoint the worker under the probation period for a period not exceeding 6 months of the date of commencing the work. And he may terminate the worker's service during this period after notifying the worker in writing, at least 14 days ahead. Before, in the old law, we never experienced such a notice before termination, or even 14 days, or even 10 days, 30 days. But now it's mandatory that the worker needs to inform the employee that there is a termination on the way 14 days ahead before serving the termination. And the worker may not be appointed under a probation period more than one time. For sure, this is This is a given fact as well. And in the event that the worker wishes to move, which is the opposite of the clause number 1 of the article number 9, in this case, the worker wishes to move during the probation period to work for another employer in the state. For example, I have experienced this like too many times during the Corona and during COVID. The business was not so good and it was not stable. So I saw my colleagues serving notice and they leave immediately. The notice doesn't have 30 or 20 days, or it's a probation period, and most of us knows how to terminate a contract, unlimited contract, within the probation period. But right now, this is not anymore available. So in case that the employee wishes to leave the facility during the probation period to work for another employer, and to work is the first scenario, because there are two scenarios in this case. So the first scenario is to work for another employer. He will proceed, but with another employer in the state. He must notify the original employer, which is the current employer, in writing within a period not less than 1 month. So right now, the obligation on the employee is to serve a notice not less than 1 month during the probation period. And this is very new. As of the date of his desire to terminate the contract, today is May 1st. I'm wishing to leave the company by June 1st. So I should serve the termination right now. The termination of the contract. I should serve the notice 30 days at least before the day that I'm desired to leave. The new employer, which is the new one, shall compensate the original employer with the costs of recruiting or contracting with the worker unless agreed otherwise. And this is very important because there is a new obligation between the workers, between the employers. There was no such obligation in the old law, but the new law regulates a new obligation between two employers, which one of them is moving his employee to another one. So there are also two outcomes we can highlight behind this. It is very important to say that no employer in the UAE has the right to ask his employee for any visa expenses, for any medical expenses, for any transportation expenses, for any plane expenses, documents whatsoever he incurred as a fees. He doesn't have the right to ask the employee under no circumstances. But he has the right for a compensation. Let's be fair. But this compensation should be paid by the new employer, by the new company. Company X, there is an employee left the company and he will join Company Z. So Company Z should know that this employee is leaving this company to join this company during the probation period. And Company Z, you should compensate my current employer with this amount as my visa. So there will be a communication between both companies, between both employers, but the main obligation is on the employee to disclose his desire that I'm leaving the company to work with this company. Nothing wrong with it, but it should be followed as that. So both rights are protected, and at the end we are fair between the employee and the employer. So once again, if the employer wishes to terminate the employee during the probation period, he should serve a 14 days notice. And if the employee wishes to leave the company for good to work for another company, during the probation period, a 30 days notice should be served to the current employer, disclosing every detail that I am leaving the company, I'm joining other company, as I have signed the offer letter, and this is the company information, so that the current company can contact the new company, ask them to reimburse all of the visa and everything. And by the way, that's noteworthy as well. So we are asking, why am I have to pay for that? And then I will pay again to onboard the employee. The good thing is that the visa and all entitlements would be moved to the new company, and the new company will not pay an extra fees to onboard the company, or to it will be only paid as to modify the contract to modify the employer, the sponsorship, and everything related to the contract, but all major fees which been paid already to the employer will not be paid again. And there is also another event, which is talking about the foreign worker wishes to terminate the employment contract during the probation period to leave the state. In this case, the worker, the employee, will not join another company, will not establish his own company, will not work on a freelance, he will just leave the state. In this case, he must notify the employer in writing at least 14 days prior to the date specified of the termination of the contract. So there is a difference between the employee. So the employee itself has two scenarios. First, he's joining another employer, then 30 days notice must be served. If he's leaving the state, then 14 days must be served. And we shall continue to state the following. In the event that he wishes to return to the state, so he already served 14 days notice, terminated, left, and then he wishes to come back to the state and obtain a new work permit within 3 months, as of the date of leaving, the new employer shall pay the compensation stipulated in the clause 3 of this article, the previous clause what we were talking about. So the new labor law conserves the right to the new employer to reimburse within 3 months, not only immediately. So even if the employee is moving to company Z, and before he joined company Z, he felt like, no, company Z is not really a good option for me, I will go for company T. This is another company, and his original employer is still there, and it's within the 3 months, whatsoever employer he will join, he should reimburse to the previous employer all the incurred expenses paid to onboard this employee to the previous employer. So within 3 months, if he's leaving the state and he wishes to come back to join a new employer, within 3 months, the new employer should compensate the previous employer. Shall pay the compensation stipulated there, unless agreed otherwise between the worker and the original employer. So if the worker we can understand that the worker can take over this obligation to be executed from his side, meaning to say, just put my new employer outside of the picture and I will pay all the fees that you incurred. This also can go, or he can just associate the new employer to pay the compensation to the current employer. Clause 4 saying that if either party terminates the employment contract without observing the provisions of this article, means without serving the notice and without actually observing the article itself, it shall pay to the second party a compensation equal to the worker's wage for the notice period or the remaining period of the notice period. Meaning to say that in this article, they are aiming to serve the notice period. If any of the parties ignored the notice period as stipulated in this article, then the same wage, and by saying wage, that means the whole salary, basic compensation, leave, transportation, accommodation, the whole salary, not only the basic wage, means the total salary. So a compensation will be equal to the worker's wage for the notice period. So if the notice period is 30 days, that means a full month's salary. If it's 14 days, that means a full half month's salary as per the notices, because we couldn't see more than 14 days and 1 month. This is the highest period when it comes to the notice period. And if the foreign worker leaves the state without being bound by the provisions of this article, he will not be granted a work permit to work in the state for a period of 1 year of the date of leaving the state. Definitely, we had the same experience in the previous law, but it was a bit exclusive in only one situation, which is limited contract. You serve, you breach a limited contract, you get 1 year labor ban. But here, even if you did not breach the contract, even if you served the 14 days notice, but you did not follow the articles, especially Article 9, you did not follow the provisions in this article, the employee will not get a work permit in the state for a period of 1 year. And by saying state, I think if we went back to the definitions of this law, we will find the state means the entire UAE. So you can't do this in Dubai and search for work in Abu Dhabi. It's the same state. The ministry may exempt some job categories, skill levels from the specified. Yeah, it's also the same, that this penalty could be waived on certain job skills and specifications. We'll continue with the leaves, and also the leaves is a very interesting topic to be brought up. The leave system, according to the new law, has been greatly changed, and the additional leaves and the new leave system enables the employee to use various leaves according to the situation he's passing through. Well, actually, we can say that the new leaves are designed especially to fulfill the needs of the worker, the employee, whatsoever the nature of the employee. I mean, male or female, both of them has special and different needs, and the new law covered the needs of both of them, as we will see right now. We can start with the annual leave, which is the most repeatable question, which I always receive, is in regards to the full payment or basic. When it comes to the annual leave calculation, is it a full payment? Is it basic? Is it basic plus accommodation? We will see that now. So the worker shall be entitled to an annual leave with full pay, not less than 30 days for each year of his extended service. The year has been defined in this law as 365 days, full Georgian year, full year, 365 days. Below 1 year, joined May 1st, 2020, May 2nd, 2022, is entitled to 30 days full payment, full paid. I think most of us know that, but I want to highlight this fact that it comes in the full payment. Same thing. Same thing if the employee did not use the leave at the time and he wished to reimburse later in the gratuity, in the end of service, full payment as well, as we will see now. So 2 days for each month if his service period is more than 6 months and less than 1 year. So in this case, we might understand that before the 6 months, employee does not deserve any leaves. But under the new law, we will navigate the fact behind if the employee served 5 months only. And he is asking for a leave, he's asking for urgent leave for some reason that will be brought up now. And a leave for parts of the year, of the last year he spent at work, in the event that his service ends before using his annual leave balance, means that he serves 1 year and 7 months. 7 months will be 2 days each month. The part-time worker is entitled to annual leave according to the actual working hours. The full-time worker is entitled to an annual leave according to the days of work, as we have experienced it now. But here the part-time is according to his actual working hours. The employer may agree to grant the worker a leave from the balance of his annual leave during the probation period. And this was the scenario I was just talking about. What if the employee spent 5 months working in the facility and he came to you as a CEO and tells you that I have a situation that I need to be there and I want to consume 10 days from my annual leave. His annual leave is in the future. He's still 5 months below the 6 months. So he doesn't even deserve 2 days per month as per the law. But in this case, the new law grants the employer the right to give and agree and grant the worker a leave from the balance of his annual leave during the probation period, and the worker shall retain the right to be compensated for the remain of his annual leave balance if he have not passed the probation period. If we read the last part again, that would bring a lot of questions, which is the worker, the employee shall retain the right to be compensated for the remain of his annual leave balance if he have not passed the probation period. Means that the probation period, they have calculated exactly same as if you did not pass the 1 year and you're below 1 year and 6 months. They have included the probation period, but conditional. It is not, it is unconditional, it's conditional, that he needs to pass the probation period, because here the condition is he have not passed the probation period. And we will see the following, as it says, the worker, the employee, must enjoy his leave in the year of entitlement. The employer may determine the dates of these leaves in accordance with the work requirements and in agreement with the worker. In agreement with the worker, not forced to, in agreement, or grant them in rotation among the establishment's workers in order to ensure the progress of his work. And in order to ensure the progress of his work is actually a clause in this law, number 4, that one of the obligations from the employer side is to secure the environment that the employee can work according to the work title in his visa. So, and he must notify the worker, the employee, of the specified date of enjoying his leave at least 1 month in advance. So the employer has the right to refuse the annual leave requests, and that will be based on the requirements, the work requirements. For example, some facilities are facing a very heavy workload during winter. Some facilities are facing heavy workload during summer, and in both cases, all employees should work together to push the company towards a very successful target. And in this case, if 1 or 2 employees wants to go on a vacation at the same time, then the employer has the right to retain one of them request and to refuse it or to postpone it later, just to pass the workload or to pass whatever the company is passing through. However, there is a limitation to that. The employer cannot just refuse based on a workload for more than one time. So for more than 2 years, it is prohibited that the employer has the right to refuse the annual leave request. He just have the right to refuse only one time. So by the next year, the employer should be well planned that this employee will get his annual leave. And of course, by the next year, the employee will deserve 60 days, 30 days from the past year and 30 days from the current year. Also, the employee should notify the company that he will have his leave on this date, which will be 1 month in advance. But we as legal team or as HR team, we always advise the employees to give us a notice 6 months ahead, 4 months ahead, 5 months ahead, so that we can plan the leave for this employee. We can hand over the tasks to his fellows in the company. We can find a replacement if he's going more than 1 month. So both sides are fairly enjoying their rights. In this clause, we can say that the worker may open the approval of the employer. So the employee may open the approval of the employer, and in accordance with the applicable organizational regulations in the establishment, carry forward the balance of his annual leave to the following year. And this is applicable only one time. It can't be repeated. So if the worker, for example, is working for 13 years, he cannot do that for the 13 years, just one time only. And the worker is entitled to the wage for the period of his annual leave. And as we defined the wage before, wage means full salary. And that was regarding the annual leave. There is also a rest days. Rest days means the weekends. Rest days means the holidays in the States. Rest days means Eid, Ramadan, and whatever festival that the state regulates as an off day. So it's whether it's established by law or by the agreement, shall be included in the annual leave. Sorry. Meaning to say that if the employee is enjoying his annual leave, which is 30 days, and for sure during the 30 days, it will fall like 2 or 3, maybe 4 weekends, which is 8 days, those 8 days are calculated from his annual leave. So it's included to the annual leave period. If the annual leave enjoyed by the worker is interrupted by and is considered part of it, unless the employment contract or the organizational regulations in force in the establishment stipulates what is more beneficial to the worker. What is the meaning of organizational regulations? And this is something I would like to directly address to the companies, especially the companies, not the firms. There is a bio policy for each company that it should be there. It should be written in a place that all employees can look, read, and understand what is this. Bio policy means internal policies for the company. Some companies are doing this in a very professional way. When you are signing a contract or an offer letter with the company, there will be more documents to be signed, which is one of them is the bio policy. Bio policy is one of the most important document that the company can later on protect its rights if the matter was raised before the courts. The bio policy was literally mentioned in the law as a mandatory document that the employee should read, understand, and sign that he understood the bio policy. The bio policy is very simple set of policies that the employee should attend this time, should leave this time, should wear this dress, should retain his personal look, should for example, should notify the employer that he's leaving. He will use his before. So it's all the regulations which stipulate the relationship between the employee and his colleagues, employees, and the employer inside the facility itself. It's very important. It should be there. And this is the meaning of organizational regulations enforced in the establishment itself, because we have no law above the law. It is one law. But this law could contain this bio policy, and the bio policy is very important. So I'm directly advising to have such a bio policy in every company. That will be a very good decision. The employer may not prevent the worker from benefiting from his entitled annual leave for more than 2 years, and this is something I have indicated before. That the employer doesn't have the ultimate right to refuse just 2 times to refuse for more than 2 years. So this year, next year, 3rd year, he can't do that unless the worker wishes to carry it forward or obtain a cash allowance. So unless it's connected exclusively to the employee decision, the employer shouldn't interfere the employee decision, shouldn't affect his decision of taking the leave it, take an impersonation of money, of cash. The employer shouldn't interfere any of these. The employer has, as we call it, a veto right. Like, no, I'm actually not agreeing to your request on the leave for this year. For the 2nd year, for 3rd year, no, you have no right to refuse this. So the employer may not prevent the worker from benefiting from his entitled annual leave for more than 2 years, unless the worker, the employee, wishes to carry it forward for the next year or obtain cash allowance. Maybe he's facing some financial problems in accordance with the organizational regulations in force in the establishment. Again, the bio policy jumps into the scene again, and actually, it's seriously, it's very important that the organizational regulations to be everywhere in the company. And noteworthy, it should be also translated in all of the languages that the work environment contains. So Arabic, Spanish, English, Urdu, Hindi, everyone read, understand, sign, and agrees to follow these biopolicy later on. And this is practical example. Actually, this is an example that we are always facing as a legal team. They come to you, my employee comes without necktie, like he comes without a formal, the color of the suit is not formal. What do I do with him? And at this time, the first question you're asking, is there a biopolicy? This is very important, because if there is no biopolicy, there will be no action taken against him. If you try to terminate him based on that, this is not a reason could be eligible to a termination. The worker is entitled to receive wages for the days of the entitled rest days if he leaves the work before using it. So that's agreed, actually, regardless of their duration in relation to the period of which he has not obtained his leave. And finally, the executive regulations shall specify the rules and conditions for organizing vacations and the compensation for them. And by reviewing the executive regulations, you will understand more and more how to deal with the vacations and how to handle your employee requests without making a scene, without break the relation between the employer and employee, because the refusal is always sensitive matter, and not only for the vacation but for the employee request. That was for the employees, whether male or female, and we will go back to the male employee, since we will now talk about the female employee, the maternity leave, which is, I see that it is a phenomenal amendment in this law, in the new law, because in the previous law it wasn't that effective. But here we go. The female worker shall be entitled to a maternity leave of 60 days according to the following. The first 45 days was full pay. Previously it was only 30, and the following 15 days, as far as I remember, it was only 30. The following 15 days was half pay, and whatever comes after that, it's unpaid. The female worker may, after using her maternity leave, be absent from work without pay for a period not exceeding another 45 consecutive or intermediate days. If such absence is due to an illness suffered by her or her child as a result of pregnancy or childbirth, and that does not enable her to return to her work, said illness shall be proven by a medical certificate issued by the medical authority. And this is a valuable advice to all HR, legal teams, companies. Do not approve any ill request, work from home request based on illness or anything, unless you have a certificate from a doctor. Or otherwise, you can do, if you saw the employee is really cannot proceed work from the company, so make things easy, go proceed from home. But if you want to protect your rights, you should have a certificate from a well-known medical facility says that this employee needs 2, needs 4, needs 15, needs 50 days of leave, but it should be based on a medical certificate and not just an email. Moving on, we can say that the said illness, the claimed illness, shall be proven by a medical certificate issued by the medical authority. And this period shall not be included into the period of service for which the female worker is entitled to the end of service gratuity. So whatsoever comes after the 45 days, the maternity leave shall not be included into the end of the service, the gratuity, or the period of contribution to the retirement system means the gratuity as well. The female worker is entitled to maternity leave stated in clause 1 of this article, which we have discussed, if she gives birth after 6 months or more of pregnancy, whether the newborn is alive or dead. The female worker, in the event that she gives birth to a sick or disabled child whose health condition requires a constant companion according to a medical report, again, They are also highlighting again that it should be according to medical report, medical certificate issued by the medical authority, is entitled to a leave of 30 days with full pay starting after the end of the maternity leave period. So the maternity leave period is 45 days plus 30 days in case her child is sick, disabled, or needs a companion all the time. Full pay starting after the end of the maternity leave period, and she has the right to extend the leave for a period of 30 days without pay, not half, nothing, zero. The employer must grant the female worker maternity leave whenever she requests at any time, starting as of the last day of the month immediately preceding the month in which she is expected to give birth, and this shall be proven by a certificate from the medical authority. We can understand from this clause that the law wants to size the start and the end of the maternity leave, where I can say the start and the end can be mutually agreed between the employer and the employee as per the needs of the employee, but everything should be written from a well-known medical authority or a medical facility. Obtaining the maternity leave or the absence referred into this article shall not to her rights to obtain the other leaves, meaning to say that there is no connection between the maternity leave, and this is a given fact, and other types of leave. And in case the female worker works for another employer during the period of her leave authorized in this article, the original employer may deprive her from her wage for the period of the leave or recover what he paid to her. Not only that, I suggest not only to stop here, because this is a bad faith from the employee, and he can terminate her based on that as well. Because working for another employer was mentioned exclusively in the termination clause, which we will navigate later on. However, the latest, the minimal punishment that he can give is to just to deprive her from the wage for this period. If she worked for 30 days, 45 days, he just can ask her for compensation or not to pay her this time. It is not permissible to terminate the service of a female worker or to give her a notice because of pregnancy, or because she has obtained maternity leave, or because she's absent from work in accordance with the provisions of this article. So it should be all falls under that she's suffering the maternity, she's suffering being pregnant, or just gave birth, newly gave birth, or as stipulated in this article exclusively, shouldn't be interpreted anywhere else. After returning from maternity leave and for a period not exceeding 6 months of the date of giving birth, the female worker is entitled to 1 or 2 rest periods per day, to breastfeed her child, provided that the period of both periods shall not exceed 1 hour. So we can understand that the employee, the female employee, is entitled to 1 more hour additional to the lunch hour. It couldn't be the same lunch hour. The lunch hour is respected by law because it's mentioned in the law and in the early articles that the employee cannot work more than 5 hours, consecutive 5 hours, unless he takes 1 hour off. 1 hour off. Additional to that, if she's applicable, if she's eligible to this article, she's eligible to 1 more hour. The worker is entitled to a paid leave in the following cases. And whenever we are reading the law and we read in the following cases, that means that exclusively in these cases and cannot interpret it into another cases. Mourning leave of 5 days in the event of the death of the newborn, and 3 days in the event of the death of the mother, father, son, brother, sister, grandson, grandfather, or grandmother, starting as of the date of death. This one of the new leave system means called mourning leave, which is if unfortunately one of your relatives died and he's one of those, mother, father, son, brother, sister, that's grade 1, and grade 2, grandson, grandfather, grandmother, that's grade 3, and grade 4 as well. If one of them died, you have the right to take 5 or 3 days. The 5 is only for the spouse, and the 3 days for the even that any one of your relatives from the 2nd, 3rd, and 4th grade have passed away. You have the right to take 3 days to consider. The parental leave for a period of 5 working days. Parental leave refers to the parents, where the new law enables the parents to spend more time with the family, to bond the connection between the families. And it's something very important and on high demand these days. So the new law gave 5 days for the worker, whether the father or mother who has a child, to care of his child, to be enjoyed continuously within a period of 6 months as of the date of the child's birth. So each 6 months he has 5 days, to be understood like this way. Any other leaves determined by the cabinet. The cabinet means the executive regulations. And the question is, the law never mentioned about the compensation in this case. What will be the compensation of the first number A and number B? It will be full paid compensation. The worker may be granted a study leave for a period of 10 business days per year for the worker who is enrolled by affiliation or regularly in one of the educational institutions approved in the state in order to perform the tests, provided that the period of service with the employer is not less than 2 years. And meaning to say that if you have an employee who is studying and his service exceeded the 2 years, he has the right to receive 10 paid days per year. So yearly he has 10 paid days to perform a test, not to study, to perform a test, not to attend a lecture, to perform a test, or to ceremony. It's also same as test if it's mandatory in some countries that you need to be there, but not to attend lectures, not to raise the study hours, just for the test. The national worker, and this is especially for Emiratis, the national worker is entitled to a full-time leave to perform the national and reserve service with pay. So if he's joining the military or a national service, he's entitled to a full-time leave in accordance with the legislation in force in this state. Means that if he, for example, he's leaving to join the military, to serve in the military for 1 year, then he's entitled to have a full-time leave. In order to obtain the leaves referred in this article, a proof of the same must be provided by the concerned authorities. So the employee, if the employee came to you and gave you this proof in your hand as a document, you should refuse. You should directly contact the concerned department and to coordinate between them to give you the proof that the employee will be absent for the next 1 year, and the executive regulations as well. Right now we've reached to the termination, and the termination of the contract. I would focus on the cases of dismissal without warning. Dismissal without warning means from the employer against the employee, same as from the employee against the employer, without warning. Warning here means the notice and the warning letters, as we will see on a very, very specific clauses. Article 44 stipulates that the employer may dismiss the worker without warning. In other words, the employer may dismiss the employee without warning letter or notice or anything that might be taken as it's a warning of a termination. After, there is always a condition. After conducting a written investigation with him. Conducting a written investigation with him means that you need to send. All of that should be by email. All of that should be written in email, should be taken as evidence, because later on before the court, and this is from a practical background for the past 5 years, we saw a lot of cases falling down in the court because there is no evidence that he have invited him for an investigation. And later on, we will see more. For example, After conducting a written investigation, the decision of the investigation to dismiss shall be in written and reasoned. The employer or his representative shall hand it to the worker in the following cases. Before we navigate the cases, we need to navigate the conditions, 3 conditions to apply on all of the dismissal without warning cases. So first of all, conduct a written investigation. Directly send to the employee on his personal email, CC his corporate email, and also the HR team, the legal team, whatsoever in the company, that we are inviting you for an investigation in regards to this incident happened on this day. Kindly be there at this time. This is an evidence that I have invited him to an investigation, or her. What if he did not respond? It's okay. You've invited already. So you applied the first condition. The decision to dismiss shall be in written and reasoned. Reasoned is very important. Reasoned is really important. A lot of termination letters are issued without reason. There is, excuse me. The reason could be a valid reason, could be considered reason, could be not valid reason, could be whatsoever reason, but it should be reason. We are terminating you based on 1, 2, 3, 4, 5, 6 as a decision. We decided to terminate your services immediately. The reason here, I would say that it should fall under the following cases, exclusively under the following cases, if you are aiming to win a case before the court. If there is no coordination between you and the employee, and you fear that the employee will go directly to the court with the dismissal letter, and he will sue you before the court, then your reason should be as the following cases, 10 cases exactly. After conducting a written investigation and write it and reason it, the employer or his representative shall hand it to the worker. This is very important. Also, I'm receiving a lot of questions. The employee refuses to sign the investigation or the decision or whatsoever. The employee shouldn't sign. The employee, you as an employer or as a representative from an employer, you've took a decision. He is not associated with you in this decision. This is your own decision. You will take over the consequences, and I have decided to terminate your services. So the decision should be served by email into his personal email, corporate email in CC, and whatever in CC from your colleagues. But it should be delivered or handed. Do not wait for his signature. Do not wait for his acknowledgement. Don't mention in the email, please acknowledge, receive. No, I'm not waiting for acknowledge. I delivered it. I handed to the email that you're using it into our interviews, into our correspondence in the corporate, into this is the email that you are using it. And the law obligated me to hand, not to acknowledge or wait for your acknowledgements. The employer or his representative shall hand it to the worker in any of the following cases, and I added exclusive cases because it's very, very, very exclusive cases. If it's proven that the worker imprisonments wasn't in the prison, another person or has, impersonates. Impersonates means that he have introduced himself as to be another person. So I'm introducing myself to be Dr. Ahmad Gabri. I have a doctorate degree and I don't have all of that. This is an impersonate. Impersonate with another, impersonate another person, or he submitted false certificates or documents. Indeed, the documents or certificates, once discovered, a terminate shall be issued. In this case, you as an employer, you will not be waiting for his acknowledgement. You will not be waiting for his signature. This is something I truly trust. if the worker, and moreover, if this impersonate or false certificates caused any damages to the company has the right to ask for compensation against the employee, and at sometimes it reaches the criminal actions. If the worker makes a mistake that results in a grave material loss to the employer, or if the worker deliberately harms the property of the employer and acknowledges the same, by mistake, making a mistake is actually could be defined as per the seniority level of the employee. It's not like I made a mistake. Okay, what's your seniority level? You're a senior, you're a manager, you're a supervisor. You can't say I made a mistake. It should be said an accident happened. There is an accident happened in this case. There is an accidentally happened that, but not a mistake. Or if you are in internal level, entry level, junior level, mid-level, yes, you can say I made a mistake. However, if this mistake results in a grave material loss to the employer, or if the worker, the employee, harms the property, intentionally harms the property of the employer, and acknowledges the same, how he will acknowledge the same? They are the investigation, conducting an investigation, and the investigation should be very detailed on the incident itself. So an investigation, and the investigation I would recommend before 48 hours of the incident to have an investigation. 48 hours only. Investigation should be an introduction and general questions. Did you came to the work on this day? What time did you came? What time did you punch in? How was the atmosphere inside the company before the incident? And did you committed this? The company or the company representative charges you committing 1, 2, 3, 4, 5, 6. That's in case of material loss or harms the property, because these are damages. Damages means compensation. Compensation means liability. Liability means acknowledgement. Provided that the letter shall inform the ministry of the incident within 7 business days. That's why I'm recommending 48 investigations, so that you have ahead of time to the Ministry of an incident within 7 business days. Let me give a live example. An employee put a fire in the archive of the company intentionally, and the cameras caught him and everything. Of course, aside from calling the police, aside from doing a criminal case against them, you should also inform the Ministry of Labor of this incident to protect your rights as an employer, aside from the criminal rights, aside from the civil rights as compensations and everything. As of the time of his acknowledgement of the incident. Also, if during working hours he's found drunk or under the influence of narcotic or physitropic substance, or has committed an act contrary to public morals in the workplace. And I would like also to share an experience that I have had before representing a company, that the company was claiming that an employee is about to raise a complaint at the Ministry of Labor on the background that they have brought alcoholic drinks into the company. This is definitely contrary to public moral in the workplace, because it's in the same clause as saying that if during working hours he's found drunk. And by the way, working hours mean working hours. The lunch hour is included into working hours, meaning to say that during lunch hour you cannot bring alcohol or do any public any acts that in contradiction with the public morals. If in the course of his work the employee commits against the employer or the manager or any of his supervisors or colleagues a verbal, physical assault or abusive or any other form of assault punishable under the laws enforced in the state. And of course, we all understand what is the meaning of physical assault. Physical assault is already known to all of us. But what is the meaning of verbal assault? Verbal assault is not only insulting, is not only cursing, I'm sorry, or saying bad words. Verbal assault, and it was a personal experience, was with someone who is very famous in some field here in the UAE, in Dubai, that he has sent an email to his colleague in another country in the GCC, calling him a drama queen. And believe me, he had received the termination based on the verb of drama queen. However, drama queen, he brought an evidence from his son, that his son is like 7 years old and he's studying in the primary school in UK. Drama queen is mentioned in one of the books that they are delivering to him, that drama queen is a very normal verb, but it puts something bad into the heart of your colleague. So this is also punishable. If the worker is absent from work without a legitimate reason or an excuse acceptable to the employer for more than 20 consecutive days or 7 20 non-consecutive days or 7 consecutive days. In this case, and the most probably that applies when the employee goes for a vacation and then he's not yet here. He's supposed to come first, he's supposed to come second. But until 12, he's not here. After the day number 7, you have the full right to immediately terminate his services 7 consecutive days or 20 non-consecutive days. The 20 non-consecutive days is per year. 7 consecutive days is 1 week, 7 days. And 7 days is not working days, it's a calendar days. As mentioned, 7 consecutive days means calendar days. 5 working days and 2 weekends. If he did not send an email in the weekend that he's in the country and he will show up on this day, and you should reply if any case. For my colleagues from the HR or the legal department or whatever controls the leave system in a company, if the employee left and he did not come back after his leave and it's been 5 days, you send an investigation to him, you send an email to him. If you reply to the email that I will be in the company, in the premises at this day, on this day, this is an undertaking from his side. If he did not show up, send him an email on the same day. He did not show up. Based on that, we will conduct an internal investigation and we will let you know the decision. By the end of the day, thank you very much, you're terminated. As well as you can also complain at the Minister of Labor. You can put an abscond case against them. You can initiate a lot of actions, especially on this clause. If the worker illegally exploits his job position to obtain personal results and gains, and this is also it has 2 sides. It has criminal side and civil side. Aside from the labor rights that the employer should claim against the employee in this case, because illegally exploit his job possession, that means a non-confidentiality breach, and also to obtain personal result, that means the bad faith of dealing as a company representative. And gains, of course, the gains should be legitimate. If it's not legitimate, that's criminal. If the worker works for another establishment without complying with the controls and procedures established in this regard, and the controls and procedures wouldn't be known unless we have the biopolicy, we have organizational policies inside the company. Eventually, we can speak about the end of service. I know that this is an exciting topic, and it's very interesting to be brought up in this webinar. We have Article 51, which stipulates the gratuity for the full-time workers. The national workers is entitled to an end of service gratuity over the end of the service. And in accordance with the legislations regulating pensions and social security in force in the state, for those companies who have hired Emiratis and local citizens, I would strongly recommend you to check on the executive regulations in regards to this article to understand exactly what does it mean. What does it mean in accordance with the legislation regulating pensions and social security in force in the state should be understood to avoid any penalties. The foreigners, the foreign full-time worker who has completed 1 or more years of continuous service is entitled to an end of service gratuity upon the end of his service, calculated according to the basic wage. This is very clear as follows. The wage of 21 days for the first 5 years of service, less than 1 year, there is no gratuity. The wage of 30 days for each year in excess of that. That refers to the 5 years. In case the worker worked for 5 years, and then you continue 1 more year, the calculation should be as follows: 6 years based on the 30 days, not 5 years of 21 and 1 year of 30. I'm just clarifying this point because that also may raise a confusion at some stage. If he is working for 5 years, then he's eligible to receive 21 days for each year based on the basic. For the 6 years, if he entered into this scheme of 6 years and above, then all the previous years should be dealt with as 30 days per year. And the foreigner worker is entitled to a bonus for parts of the year in proportion to the amount spent on work, provided that he has completed 1 year of continuous service. A bonus for parts of the year in proportion of the amount spent on work, provided that he has completed 1 year of continuous service. The days of absence from work without pay shall not be included in the calculation of the duration of service. Means that in this case, if he worked for 356 days, 1 full year, but he was absent for 4 or 5 days, then he's not yet 1 year. Is less than the year. Payment of workers' entitlements at the end of the contract. The employer shall pay the worker, the employee, within 14 days of the date of the end of the contract. A lot of questions from an employee comes and says that I have signed the full and final settlement, I have signed the termination, I've signed the visa cancellation, and until now it's been 50 days I did not receive my entitlements. In this case, he can go to the labor and submit a case against you. It's only 14 days that you need to pay everything to the employee, his wages and all other entitlements stipulated in this decree by law, and the resolutions issued in implementation thereof, the contract or the establishment's articles of association. And eventually, I would give a very valuable also information that all companies has until the February of 2023 to modify all the contracts from unlimited to limited and to proceed with the new regulations and the new law. As you can see, the new law has a lot of good features in both sides, to the employee and the employer. It protects the interest of both of them, and for more better professional and career progression. Thank you very much indeed for listening to me and attending to this webinar. It was really appreciated. And I will give the word to the Spanish Business Council. Thank you very much.
Thank you, Ahmed. Thank you very much. Thanks to the attendee for still being here, because it's been a little bit long, but I think like really appreciate for them because they are all here. So that's great. Thank you very much. There is a question, but I unfortunately, as the webinar has been a little bit long, I think that we don't have too much time, but I don't know if Andrea Hernandez has a question. Andrea?
Ay, disculpa, no sé por qué se me quedó la manito arriba. Sorry, I don't know why my hands are up. I cannot undo it. Thank you very much, Ahmed. The information was great.
Okay, thank you. No worries at all. Okay, so I think there is no question then. So thank you very much, Ahmed and Alejandra. It's been a pleasure. I'm sure that some of our okay, Luis Felipe. Hi, Luis Felipe.
Hi, I posted my question actually on the Q&A bar.
Okay, but go ahead.
So I'll go ahead. It's a practical question about calculating the end of service gratuity and in this new scheme. So I understood about 21 days for each year of the first 5 years, right? Now, the example being, if there is an increase in the basic salary of the employee, right? So in my example is, if I have an employee, this person has 1,000 dirham salary, basic salary in year 1, and then 2,000 dirham salary on year 2. And then this person quits or ends the job, and I have to calculate end of service. Do I calculate those 21 days? Let's say 21 days on 1,000 and for the first year and 20 days on 2,000 for the second, or all the 2 years on the 2,000?
According to the last payment, all years on 2,000.
Great, thank you very much.
You're most welcome.
Okay, so I'm writing now in the chat because there is a question. In a couple of days, the video recording will be available in the Spanish Business Council YouTube channel. Okay, so if you want to watch again, because I know there are a lot of information, data, and everything, and perhaps you need to watch it again, you will have the video available in our YouTube channel. Okay, so Alejandra, Ahmed, last time to say thank you very much. It's been amazing. Thank you.
Thank you, Alejandra. Thank you, Spanish Business Council. Thank you for all the attendees. Thank you very much.
Bye.
Goodbye.